You are watching Morning Musings with Reinhard von Hennigs, chairman and founder of Bridge House Law in Charlotte, North Carolina.
Have you ever rented a car? Hello, this is Reinhard von Hennigs. And let me be a little bit more precise. Have you ever rented a car and read all the fine print? The answer is probably yes, you have rented a car, but no, you did not read the fine print. And here's the issue. A renter showed up, picked up the car, most likely in the same rush as you and I are in when we are at an airport or a train station, where we can't wait to get out of the location and drive our happy way to our destination. So this renter signed a 1 month, 30-day usage, and it was unlimited mileage. So guess what he did? He used his unlimited mileage package, but drove about 25,000 miles in 30 days. 25,000 miles is about 40,000 kilometers. That's a bit more than the circumference of our planet. So how he managed to drive 25,000 miles in 30 days is a different question. But here's what happened. Hertz implemented a $10,000 penalty because, so they argued, it was a violation of the fair usage clause. So let's talk about the fine print. Let's talk about the fine print and what does it mean for you. Why global business operators must master the contract terms even in the fine prints. Imagine you have a deal which is airtight outside of the car rental, and you overlooked one important clause which then cost your company millions. It's a nightmare, yes. It's a nightmare, but many companies face this pitfall regularly due to ambiguous terms, overlooked jurisdictions, or maybe forgetting that the interpretation of law differs from country to country. So let's talk a bit about what does it matter for global businesses. First of all, you have the power of being precise in the drafting of the contract. You can make it work. Many businesses believe that having a good boilerplate, a good standard terms and conditions will save them. But in reality, the more specific the deal is, the less likely something which is not tailored for you will work, the more likely you need something tailored for you. So only in a tailored contract you can, for example, define key terms explicitly. So in this case with the car rental, what does really unlimited mean and where does a fair usage stop the unlimited clause? Set clear expectations of scope, of usage, and of penalties. Specify how disputes will be resolved, arbitration, mediation, or litigation. And finally, align your contract with the jurisdiction's framework where the contract is being used. So had the car rental company specifically define what unlimited mileage is and what fair usage is, the dispute might have been avoided. Number two, review the contracts from your business partners. So really, do you know what are you signing? Or even more, do you know what your salespeople are signing? Because salespeople are very often out to do one thing, to sell. Businesses, as we know, don't always take their own contracts. They take contracts from vendors, suppliers, and partners. So look in those contracts which are presented to you for hidden clauses. Are there any penalties, restrictions, or automatic renewals buried somewhere in the fine print? How is force majeure governed? How do unforeseen global events like pandemics or war, supply chain disruptions impact the obligations? What are performance metrics? Are deliverables and timelines clearly defined? Because only if those are clearly defined, you will avoid later disputes. Let's talk about the indemnification and liability limits. Who bears the financial responsibility for any breaches or any failures? Let's think. You are a European company and you are partnering with a US-based logistics provider. If the US company includes a clause for limiting the liability for a small percentage of the contract value, the European firm could be exposed to a massive risk in an event of non-performance. Number 3, what are the applicable laws? Does it really matter, and would it lead to somebody having the upper hand? In our experience, one of the most overlooked aspects of contracts are the jurisdictions and governing laws. When companies enter agreements cross borders, they must decide which country's legal system will apply to solve their disputes or to figure out under which laws the dispute should be solved. There are significant differences between the outcome of litigation, the enforcement of judgments, or even regarding to the interpretation of a contract term. Let's think about a German company who signs a contract with a Canadian partner, but the contract states that all disputes will be resolved in New York. Is this favorable for the Canadian? Is this favorable for the Germans? I have no opinion about that, but you need to know what you are signing and think about what's more beneficial for you. A well-structured contract clause clearly specifies the governing law as well as the dispute resolution mechanism, and this will ensure that the businesses are not disadvantaged. So why does it matter for global businesses? Poorly drafted contracts or loosely reviewed contracts can lead to unexpected financial losses due to hidden clauses, due to reputational damages when the disputes go public. Think about this Hertz rental situation. It can lead to legal battles across multiple jurisdictions, which would result into draining of resources, and it can be a disruption in supply chains due to unenforceable agreements. The car rental case is just one example how unclear a contractual language can lead to disputes, customer dissatisfaction, potential legal battles, and how this little video clip went viral, also to damage in the reputation. In a global business context, those risks are amplified due to cultural and linguistic differences and to the speed of the internet. So as a CEO, as an owner, as an operator of a company, make contracts which work for you. You are mastering the art and science of contracts because it's not just a legal necessity, it is your strategic advantage. So here are my 4 takeaways. Number 1, conduct regular contract audits. Have your team review with in-house or outside lawyers regularly the key agreements, the key clauses for risk exposure, and to analyze how the market may have changed for a different language needed. Number 2, train your teams in contract literacy. Ensure that your managers, decision makers, and even the salespeople understand the implication of certain terms before signing agreements. Number 3, leverage technology. There's contract management software available which can help you to flag risks and, even more important, to track obligations. What are the post-contractual obligations? What are your duties and obligations 12 months after the contract is signed? When do you have to report any damages or any mechanical issues from a warranty point of view, and when is it time barred? And number 4, work with experts. The earlier you engage with experts who have cross-border experience, you can avoid pitfalls. As global business grows more complex, one question remains. Are your contracts protecting your business or leaving it exposed?
Whether you're a private citizen, an international business leader, or simply someone eager to stay on top of the latest news, this book is a great way to get caught up on the most recent developments in the worlds of international business, tax, politics, and social affairs. Go to morningmusings.com and order your copy today.
Thank you for joining us today. If you would like more information about Bridge House Law, please visit our website at bridgehouse.law. Before you go, make sure to like this video and subscribe to the channel for more up-to-date content. Bridge House Law, business-minded, client-focused.